I want to tell you about him before I tell you about the case, because by the time most people hear about cases like this one, the person at the center of it has already become a file number, a plaintiff designation, a name in a brief. He was not a designation to me. He was a man who walked through a door asking for help, and what he received instead was contempt delivered with a smile. I want you to know him before I tell you about the woman who smiled. I have held this story for a long time, not because I was afraid to tell it, because I wanted to tell it right. Subscribe and turn on notifications. That is the only reason I am here today, to tell it right to the right people. Subscribe before I keep going. Let me begin where the story ends, in the silence. After I spoke the sentence, the courtroom went so still I could hear the air conditioning cycling through the vents above my head, not voices stopping, not the room settling. The specific, complete stillness of a room where something permanent has just been said and every person in it understands there is no revision coming. I'm going to come back to that silence, but first I need to take you to how we arrived there, because a silence like that does not come from nowhere. It comes from everything that happened before it. Marcus Tillman was 41 years old when this happened. He had been unhoused for 14 months, a fact I know because it was documented in the case record and because he told the court himself in a voice that was steady, in the way voices are steady when a person has had to relearn steadiness. He was a former warehouse supervisor, 11 years at the same company. He lost the job when the regional distribution center closed, and the losses that followed came the way losses tend to come. Not one at a time, but in sequence, each one making the next harder to stop. Apartment, savings, a mailing address, the ability to show up somewhere clean. He was not a man who had stopped trying. That was the thing I noticed when he first entered my courtroom. He was wearing a collared shirt that had been pressed, not ironed at home with an ironing board, pressed by hand, folded carefully, smoothed by care, the kind of attention a person pays to something when care is all they have available. He sat at the plaintiff's table, folded his hands on top of it, and looked at the front of the room, not at me, not at the defense table, just at the front of the room, the way a person looks at the horizon when they are trying to stay level. I have been on that bench for 19 years. I know what it looks like when a person is holding themselves together. I know what it looks like when holding together has become a discipline. Marcus Tillman had made it a discipline. Now, the other person in this case, Diane Caldwell, was 53 years old. She owned and operated a medical staffing and wellness clinic called Caldwell Health Associates, 4 locations across the county, built over 12 years. She was organized when she appeared in my courtroom. Her documents were tabbed. Her attorney was prepared. What I noticed about her was this. She had a way of looking at people that was not quite looking at them. Her eyes would move to whoever was speaking and then very slightly adjust, not away, just slightly past the person, as if she were listening to a point behind them rather than to them. I noticed it when her attorney spoke to her. I noticed it when Marcus walked in. There was one moment in 4 days of proceedings where she appeared to me as something other than a position. During a recess on the second day, I saw her standing alone near a hallway window, looking out, not at her phone, not at her notes, just out the window with an expression I can only call tired, not guilty tired, just tired, the kind that comes from running a life very hard for a very long time. I held that observation, and then I returned to what she had said, and the tiredness made it worse rather than better, because a person who is genuinely tired knows something about being without resources. She had looked at a man who was without resources and she had chosen contempt. Tiredness does not explain that. It only tells me she was capable of more than she chose. Subscribe, not for me, for the reason I'm telling this. Some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. Here is what happened on the afternoon of September 14th. Marcus had been directed to Caldwell Health Associates by a nonprofit outreach worker who told him the clinic offered sliding scale consultations for uninsured individuals. He had a cough that had been worsening for 6 weeks. He was concerned. He walked to the clinic. It was just after 2 in the afternoon. He pushed open the door, went to the front desk. told the receptionist he was there for a sliding scale consultation. The receptionist went to the back. Diane Colwell came out. According to the testimony of 3 witnesses in that waiting room, she looked at Marcus, took in his appearance, and said, and I am quoting exactly as recorded in testimony, "This is a wellness clinic, not a shelter. I think you have the wrong address." Marcus explained he had been told about the sliding scale program. He had the name of the outreach worker. He offered it. Caldwell said, "We discontinued that program, and even if we hadn't, this is a professional environment. We have other patients." There were 4 other people in that waiting room. Not one of them was being seen at that moment. No clinical reason was given, no gentle redirection, no alternative resource offered. Just a woman who looked at Marcus Tillman and decided that the professional environment she had built was not one in which he was acceptable. He left. He stood on the sidewalk for a few minutes. A witness named Patricia Osei followed him out. She gave him the address of a free clinic on the other side of the city. She told the court this quietly as if she were reporting something that embarrassed her, not because she had done anything wrong, but because the fact that she had been the one to help him meant that no one inside the clinic had. When the complaint was filed, it came to my court under the county's civil rights and public accommodation statutes. What most people do not know is that in cases like this, the threshold for establishing a violation is not the same as criminal law. I am not looking for intent beyond a reasonable doubt. I am looking at conduct and its effect on a person's access to services that were represented as available. The clinic had a posted policy. Sliding scale consultations were listed as available to uninsured patients. That policy was not marked discontinued on the date Marcus walked through that door. It was still on the website. The defense argued the program had been internally discontinued. What I can tell you is that internal decisions not reflected in posted policy are not the same, in law, as decisions properly communicated. That is not a technicality. It is why posted policies exist. It is why accountability frameworks exist. The law did not catch Diane Colwell on a loophole. It caught her on what she actually did and what was actually promised. The part that made me set the folder down for a moment was the witness statement from Patricia Osei. She described Marcus standing on that sidewalk after he left, and looking, she said, like someone who had just remembered something he had been trying to forget. She did not say what. She did not have to. I have sat across from enough people to know what that kind of remembering looks like. That is the limitation of my role. I can respond to what reaches my courtroom. I cannot reach back to what happened on that sidewalk before anyone decided to file anything. I have made peace with that distinction in the sense that I have accepted it. I have not made peace with it in the sense that I have stopped feeling its weight. On the morning the trial began, I watched them both enter. Caldwell came in at 9:03, 2 minutes after the time I had asked all parties to be seated. She moved to her chair with the efficiency of someone who has moved through professional rooms her whole life, portfolio open, pen ready. She did not look up. Marcus came in on the right side, same pressed collar, a manila folder, the kind you buy at a drugstore. He sat down and placed his hands flat on either side of it, as if he were steadying something that might move. His attorney, a young woman named Priya Mehta from a legal aid organization, leaned over and said something quiet to him. He nodded once. What I noticed from the bench that no one else was positioned to see. When Caldwell finally looked up, her eyes moved to her attorney, to the gallery, to the window, not to Marcus, not once. In 4 days of proceedings, she managed to never actually look at the man she had turned away from her door. The slight adjustment I had noticed in that first moment, that look slightly past the person in front of her, she held it for the entire trial. Subscribe before I go further. I have more to tell, and the more I tell, the more it matters that someone is listening. Subscribe and stay. There were 3 moments in that courtroom where the room went completely quiet, not the quiet between sentences, the kind that settles when something true has entered the room and no one knows what to do with it yet. I'm going to tell you about all 3. The first silence came on the second day of testimony. Marcus was on the stand. He had been describing what happened at the clinic with the careful precision of someone who had replayed it many times and was committed to accuracy. His attorney asked him what he thought when Caldwell told him he had the wrong address. He paused. Not a thinking pause, a different kind. The pause of someone asked to put into language something that has been living in them without language for a long time. He said, "I thought I had misunderstood something, that I had got the information wrong. I thought it was my mistake." The room went quiet. Not because it was dramatic, because it was so plainly, specifically true that nobody had anything to add to it. He had walked into a place that posted its welcome publicly, been turned away, and his first response was to assume the error was his. I sat with that from the bench. I did not write anything. I just let it be in the room. The silence lasted about 4 seconds. Priyameda broke it by asking the next question. But those 4 seconds were the first time I understood, not just legally but fully, what this case was about. It was not only about a policy violation. It was about what it costs a person when they have been made to believe over and over that the wrong door is always their fault. The evidence surrounding that silence was the baseline of the case, the posted policy, website records, the outreach workers' referral documentation, 3 witness statements, a photograph of the clinic's posted fee schedule, still listing sliding scale consultations as available. The facts were not in serious dispute. What was in dispute was what those facts meant and whose responsibility they were. If you are still here at this point in the story, you already understand something important about why I am telling it. Subscribe. This is what I do now. I tell the cases that stayed with me. Subscribe and you will hear the rest of them. I want to tell you about something that came back to me during this case, a memory from my own life that I have not placed in any legal framework. When I was 32, I was between positions, a short period. I had savings and family who could help me. I walked into a government office to ask about a temporary assistance program. I was wearing a good coat. I had my documents. The person at the desk helped me immediately, told me everything, gave me the forms. I have thought about that for a long time. What happens in the version of that interaction where I am not wearing a good coat, where I do not have a permanent address to write on the form? I do not know what happens in that version. I have never had to find out. Marcus Tillman spent years finding out. I placed that memory next to this case the night before I delivered the ruling. I did not ask it to tell me what to do. I let it sit there. Then I returned to the law. The defense arguments came in careful layers. Caldwell's attorney submitted evidence that the clinic had, in the previous year, served over 200 uninsured patients through the original sliding scale program. He argued this demonstrated his client was not opposed to serving vulnerable populations, only that the program had reached its capacity for that year. I looked at that record carefully. It was real. It gave me genuine pause. It suggested the situation was more complicated than simple hostility. Then I returned to the words she had used, not which policy she invoked. What she said, "This is a wellness clinic, not a shelter." Those words are not the language of capacity management. They are a judgment about who belongs in a space. The record of the previous 200 patients did not change what those words were. It only told me she was capable of more than she chose that afternoon. Caldwell testified on the 3rd day. She was composed. She acknowledged saying the words attributed to her. She said quietly that she regretted how they had sounded. She said, "I was thinking about the other patients. I was thinking about maintaining an environment where people felt comfortable." I wrote that down. I looked at it for a long time before I moved on to the next page, because in that statement was something she had not intended to tell me. Marcus had never registered to her as one of the patients she was thinking about. Even in her most careful retelling of her own behavior, he was not in the category of people she was protecting. He was the thing she was protecting the others from. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. The second silence came at the end of Caldwell's testimony. Her attorney said he had no further questions. The room waited for Priyameda to begin cross. She stood, looked at her notes for a moment, looked at Caldwell and said, "I have no questions for this witness." The room went quiet in a completely different way than the first time. Silence 1 was the stillness of something true being said. Silence 2 was the stillness of something true being made visible without words. Priya Mehta had decided that Caldwell had already said enough. The testimony stood, and the room understood that. Every person in that courtroom understood in that moment that the case had already been decided by the words the defendant had spoken in her own voice. This silence was longer, maybe 10 seconds. Caldwell looked at her attorney. Her attorney looked at his notes. The gallery was completely still. What that silence told me was that there was nothing left to revise, no context to add, no alternative reading to place beside the one that existed. The gap between what was argued and what was true had been visible since Silence 1, but Silence 2 was when everyone stopped pretending the gap was closable. A county human rights investigator had testified earlier that day, a methodical, quiet man who had reviewed 43 public accommodations complaints over 3 years. He said without flourish that this was among the clearest cases of discriminatory conduct he had seen because the discriminatory language was documented by multiple witnesses and because no administrative record existed to support the claim that the program had been discontinued on the date of the incident. He said, "In my experience, when a policy change happens, there is paperwork. There was no paperwork here. I noted that in my ruling. I have not told you what I ordered yet. I am about to. Subscribe before I do. Not because it is dramatic, but because I want to explain every part of it, and I want you to be here for the explanation. Subscribe now." I had made this decision carefully. I had made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case they were. When I spoke the sentence, the room went still the way I described at the beginning, and now I will tell you what I saw inside it. Marcus Tillman had his hands flat on the table as he had every morning. When I finished speaking, he did not move for a moment. Then he let out a breath. It was not a sob, not relief exactly. It was the sound of a person who has been holding something for a long time and has just been told he is allowed to set it down. I heard it from the bench. I do not think anyone else heard it. Here is what I ordered, in the order I ordered it. I am ordering you to pay damages of $47,000 to Marcus Tillman, $12,000 directed through the county's legal aid housing fund, the remainder paid directly to the plaintiff. The $12,000 going to the fund is not a fine paid to an institution. It is payment directed to the resource Marcus needed access to on September 14th and could not reach because of your conduct. The connection between what you withheld and what you must restore is not symbolic, it is direct. I am also ordering the suspension of Caldwell Health Associates' certification as a participating clinic in the county's low-income healthcare referral network for a period of 2 years. During those 2 years, your clinic will not appear on any resource list given to uninsured patients. Outreach workers will not send people to your door. You decided who was acceptable in your space. For 2 years, the county will participate in that decision differently. I am also ordering 200 hours of community service to be completed specifically at St. Augustine's Free Clinic on the east side of the city, not general volunteer hours. Direct patient intake and waiting room assistance in a facility that does not turn people away based on appearance, where every person you serve will be a person like Marcus. I am ordering this not as punishment for its own sake, but because I believe proximity is what changes judgment in people who are capable of being changed. I am choosing to believe you are capable of it. I am ordering a formal written public statement to be published in both local newspapers of record and posted permanently in the waiting room of each of your 4 clinic locations. The statement must acknowledge specifically what occurred on September 14th, must name the policy that was misrepresented, and must commit to a specific protocol for serving uninsured patients going forward. It must be written by you, in your own voice, without legal language. I will review it, not for self-protection, for honesty. And there is one more thing. You will provide Marcus Tillman with a full medical evaluation at a clinic of his choosing, paid for entirely by you. The cough he came to you about went unexamined for another 11 weeks. I want that named. I want the cost of those 11 weeks named and addressed. You will not oversee the appointment. You will not be present. You will pay for it and stay out of the room. Then I looked at her and I said what I am about to say to you now, the way I said it in that courtroom. What you did that afternoon was not complicated. You looked at a man who needed help and decided that the way he looked made him less than the people you had decided your space was for. You said wellness clinic, not a shelter, as if wellness were something only certain people deserve to seek. It is not. The fact that you once served 200 uninsured patients does not revise what you chose in that moment. It only tells me you knew better. To your family in the gallery, I have no accusation for you. I know you did not do this. I hope you are able to have a difficult conversation. You built a business on the promise of care. On the day Marcus Tillman walked through your door, you chose not to extend that care based on what you saw when you looked at him. What your position required of you was to hold the standard of your own posted policy. You chose your comfort over his need. This last sentence is not for you. Marcus, you walked into that room with your folder and your pressed shirt, and you told the truth in a steady voice, and you let the process work. I saw you. This court saw you. There are other people I want to speak for. Other cases where someone needed a voice in that room and received procedure instead. Subscribe and I will tell you those stories when I am ready. This was the first one I was ready for. When the courtroom began to empty, I stayed at the bench. Patricia Osei was sitting in the third row. When the session ended, she stood, reached across the row, put her hand on Marcus's shoulder, and said quietly, "I'm glad somebody listened." Then she gathered her things and left. Diane Caldwell and her attorney moved through their papers efficiently. They were the last to leave from the defense side. When I finally stood from the bench, the room was nearly empty. The afternoon light was coming through the east windows and crossing the plaintiff's table where Marcus had been sitting. The manila folder was still there, left behind, a drugstore folder in a bar of afternoon light on an empty table. That is what I noticed. That is what I have noticed every time I have thought about this case since. The appeal was filed 42 days after my ruling. The Fourth Circuit Appellate Panel heard it and affirmed the ruling in its entirety 8 months later, finding the conduct clearly documented and the sentencing proportional. 8 months is a long time to wait. I waited. When the appellate decision arrived, I read it once, set it down, and returned to the case on my desk. On March 3rd of the following year, Priya Mehta sent a brief note to the court. Marcus Tillman had received the medical evaluation I had ordered. A treatable respiratory condition had been identified and addressed. As of that date, he had secured stable housing through a program the county legal aid fund had helped connect him with. One sentence, a date, a fact. I do not know what to do with the distance between September 14th and March 3rd. I have thought about it. I still do not know. What I do know is that the question of what happens to people in the gap between when they need something and when the system finally turns toward them, is the question this case left in me. People who work inside these systems, which includes me, have a responsibility not to let that question become comfortable, not to stop feeling its weight just because a resolution eventually came. Grief and clarity are not opposites. In my experience, one tends to produce the other if you sit with it long enough. To anyone who has stood at a door and been made to believe the closed door was your fault, I recognized something in Marcus's face during that trial. A look I have seen before, in different rooms, on different faces. The look of a person who has learned to apologize for needing things. I am not going to tell you that you matter or that you are not alone. Those things are true, but they are not what I want to say from a place of real honesty. What I want to say is this. The door being closed was not your fault. It was a choice someone made. It was named in a courtroom. It was answered. To anyone who has ever made a version of this calculation, who has looked at a person and adjusted the level of care based on what that person looked like, I want to ask you the question I could not ask from the bench. Did it feel like a decision, or did it feel like something more automatic than that? Because the harm that feels automatic is not smaller than the harm that feels intentional. It is often larger. It happens more often, in more rooms, to more people. That is where the work is. Thank you for staying with this. I mean it in the specific way you mean something when it cost you something to say. Subscribe if you have not yet. You already know why you are still here. If you want to leave something in the comments, I read them. This is not a place for arguments about who deserved what. It is a place for people who understand what it costs to be turned away from a door. Those people find each other here. I have seen it happen. It matters.